Well, I mean, I think we should.
All right, court is calling 2025 CR 015559, State versus Barry Allen Mitchell. Can I have parties announced?
Espinoza for the state.
Jim Oltersdorf for Barry Mitchell.
And are you Mr. Mitchell?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Mr. Mitchell, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes,
Did you review the true bill of indictment with your attorney? Did you understand it?
yes,
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Right. Court will find that the state is in compliance with discovery. Mr. Mitchell, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Mhm.
All right, you're charged with driving while intoxicated third or more as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
yes,
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Mitchell, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
nope,
Anyone promised you anything other than the plea?
nope,
Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Mhm.
Yes. Okay, according to the plea, punishment is to be assessed at a cap of 5 years in the prison. There's a $1,200 fine. State opposes your application. This will run concurrently with 2025 CC 007232, and there's to be restitution to DPS in the amount of $60. Did you understand that to be the plea?
Yes,
Defense?
Yes, Your Honor.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
yes,
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No.
State, any evidence?
Yes, Your Honor. Proceed off of State's Exhibit 1 and all attachments.
No objections. Your
All right, did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statement and police reports, but most importantly, there'll be no live testimony. Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find that there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Honor. Yes. You want
All
to
right.
proceed with sentencing of the judge?
Anything you want to say on behalf of your client?
Judge, yes, thank you for the opportunity. I've had a real, I don't know, Mr. Mitchell is he's a very nice man. He's had a problem, even though he's had some VR problems with the interlock because he doesn't have a car. He really needs to be told by the court that it's the law and we really need to proceed with that. I know you may have received some VRs at the beginning. I was very pleased, and I'm very pleased to stand here and tell you that his latest one was, even though there's a bunch of them, that most of it were at the beginning when it was a rough road, and I was explaining that he needed to have it. And it would kind of go back and forth between the two types of interlock. But what I find to be most interesting is my interaction with his family. His daughter is one of the most educated, polite, professional young ladies. She lives in Atlanta, Georgia. I've spoken with her many times, and she's had contact with Barry, her father, to tell him, let's go ahead and resolve this. And that's why we kind of jumped the gun a little bit to be here today. He said waiting for a court date. Of course, he had another problem with the interlock, and that would have been getting him in jail. But that's the only problem I think he's got. I don't think he's gonna, I think if he's on probation, I think he'll do well. I mean, he doesn't seem to do anything of any other major league offenses as a criminal. I think that he's got some type of an alcohol issue. I know that his son lives in San Antonio. I've spoken to him once, but I'm actually most impressed with the daughter's involvement. She can't be here, and she has been right on top of things and understanding the law. And I don't know what she does, but whatever it is, it's something pretty important, I suspect. But she doesn't lord anything over anyone in that respect. But I just find my conversations with her to be, she's just a very polite person. And I think that if she was in this room today, she'd be telling you, I wish I could be in San Antonio. I wish I could be on top of my father. My father will listen to me, but I'm over there in Atlanta where I have to be, where that's where my work, my professional life is. That's what I've spoken to her about. I said, somebody's got to be here to handle him a little bit. And Barry doesn't have a whole lot of backup here other than the son. But I think that, you know, the first person you're looking at is a 1986 DWI, as the court can see.
Mhm.
He didn't get another one not too long ago. And of course, the MTR, I don't know any more of the results of that. I know there were a couple of problems with it. And then, of course, this was part of that. But I just don't see him as a kind of person that's going to go out, drink and drive and kill somebody. I mean, I don't know how else to put it. I think that if you, and I know you are a very strict person on probation, I wanted him to come and see you in court today, hear you speak and see how you do things. And I told him what to expect. And I think that if you're over him and you're the judge on his probation, and you tell him he has to have the interlock, whether he balks a little bit about it or not, that's been the only problem I've had, is he'll do what you tell him to say more than anybody. So I'm asking you to please consider giving him a chance. He was on the DWI second probation. Looks like he did pretty well for a long time. But I think he'll do fine. And he's old enough to know he's a veteran. He's not a lengthy period of time in the service. It's not a veteran issue, but I've talked to him about that. But I just think that, we're really asking you to really give Barry a chance at probation. I think he'll let him see what he can do with you. Okay.
Or any kind of, rehabilitation or something.
Okay. All right, let me hear from the state.
Your Honor, we are opposed to the application. Mr. Mitchell was placed on probation for DWI second, which was reduced to a DWI in county court just almost 3 months to the day. When he picked up this new offense, it begs the question of whether Mr. Mitchell was operating a vehicle that was not installed with ignition interlock, as is a condition statutorily under DWI, or if he was operating and planning to violate by blowing high. I think Mr. Mitchell is a danger not only to the community, but frankly to himself, and I don't think his behavior has shown he will follow.
Thank you.
Could I add one more brief thing about
Sure.
in the state? I invite them to correct me, obviously, if I say anything misleading. I believe that the driving facts in this case are pretty slim. I mean, he's operating, but I don't believe he's doing anything of any type of danger. Is that correct, counsel? Is he just basically sitting in a car with it running, or?
The law states it is operation.
No, we're totally in agreement with that. That's the law, Judge, and he knows that. I've explained it. but the driving is not a dangerous situation.
All right.
That's all I was trying to make sure the judge
Sure.
saw, and I know you did. Thank you.
Oh, yes. All right, so here's the thing. The state is requesting that you go to prison. And the most they're requesting that you go to prison is for 5 years. This is what I believe your problem is, and if I'm wrong, somebody correct me. He cannot stay sober. And I don't know why it is that people don't realize that if you're going to drink, take the via bus. If you would have been drinking and just took the via bus, the most probably you would have ended up with, which is public intoxication. But you didn't. And I know people are saying, well, I don't, he won't kill anybody, but you never know. That's the problem. I have yet, and both of you can correct me if I'm wrong, I have yet to meet anybody who's charged with an intoxication manslaughter or some type of intoxication case where they injure somebody and kill somebody. I've never seen anyone as a defense attorney, prosecutor, as a judge come before me and say, you know what? My intent was to go out and drink to intoxication, get behind a car and kill somebody. You know what it is usually is? People crying, I'm so sorry, I didn't know, I never meant for any of this to happen. But this is what you need to consider, right? You have your daughter, right? You have your son.
I was a truck driver for 30 years too.
Mhm. And see, here's the thing about that. People are on the road and some of them are intoxicated and they're driving. And when they're driving and they're intoxicated, they can hit anybody. They can hit people's children. They can hit the grandmother, and the grandmother ends up dying and she's just trying to enjoy her golden years, or he's trying to enjoy his golden years. So I do think you have a strong addiction. And I think the only way to solve that would be inpatient treatment. And when I say inpatient treatment, that will be inpatient treatment at safety or either felony drug court. That is the only way I will consider placing you on probation. So your choices are, you're going to do somebody's inpatient treatment, or if you don't want to do inpatient treatment, I'll sentence you to the 5 years.
Patient treatment.
All right. Probation. The court is going to sentence him to a $1,200 fine that will be probated. State, how long are you requesting for length of probation?
I guess. I'm sorry, Judge.
That's okay.
Maybe like 5 over 7.
Okay. So the court will sentence you to 5 years in the prison, suspended and probated for 7 years. There's to be regular reporting by Zoom or in person, regular random UAs. This will run concurrent with 2025 CC 007232. There's $60 restitution to DPS. Field visits 1 time per month until further notice. Proof of employment within 45 days of release. No employment as a home healthcare provider or with minors. DWI education course. DWI live. The impact panel live, I'm sorry, VIP live. 2-year license suspension. There's going to be 200 hours community service restitution. There'll be 1 hour deducted for every sober support meeting. I'm going to order 20 sober meetings in 20 days upon release. There's going to be referral to felony drug court in custody. There's to be a TAP evaluation in custody. If not accepted into felony drug court, then he's going to be going to safety. Probation, did I forget anything? Oh, ignition interlock.
Yeah, that's what I was gonna say,
I'm sorry.
There's
you
gonna
saw-
be
you saw
ignition.
me.
Yeah. There's gonna be
Going.
ignition interlock for the full term. Is there anything else, probation?
Judge, did I hear him say that he didn't have a vehicle?
Do you have a vehicle?
Yeah.
Well, the vehicle that you were driving or not driving or behind the wheel in this case, whose vehicle did that belong to?
That used to be my son's vehicle back then.
He needs to have ignition interlock full term on any vehicles he has access to. So if you're living with your son and your son has a vehicle,
Staying by myself.
Yeah, according to his daughter, Judge, he lives in a boarding house somewhere. We're trying to get a key to get it there. So,
well, we will see.
yes, sir.
And if for some reason, yeah, the probation discovers he has no access to vehicles, then I will consider changing that and it will be a portable monitoring device with an affidavit of non-driving. Is there anything else, probation? Anything else you need in order to be successful?
Really good chance right here.
All right.
Wrong with it.
Okay. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right.
Last document I gave you talked about.
Mhm.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, so we're off the record. Here's the thing. You know, back in the day, they used to have pastors, and you could get the pastor's speeches or their sermons, I should say, on albums. So my grandmother, my mom, they have a lot of albums with sermons by pastors. And there's one sermon that's on there where this guy, he would constantly call his mom when he would get in trouble, right?
Mhm.
He would drink, call his mom would come down and bail him out. The last time he went into custody at the jail, he was just screaming and hollering, telling them, you know, I want my mom to come bail me out. And you know what the deputies told him? Don't you know? And he's like, no, what? They're like, the person you killed was your mom. So don't be that person where you're hollering for your children and you find out that you've been driving intoxicated. You understand?
Yes, ma'am.
All right, good luck to you.
Mhm. Thank you.
Thank you, Judge.
Welcome. Who's next?
What unfolded in Judge Boyd's courtroom on February 24th, 2026 was more than just a sentencing. It was a reckoning. Barry Allen Mitchell, a man with a DWI history stretching back to 1986, stood before the 187th District Court facing a third or more DWI charge, a third-degree felony carrying up to 10 years in prison. His defense attorney painted a sympathetic picture. A veteran, a father, a man whose engaged daughter in Atlanta had pushed him to finally resolve the case. The facts on the ground were notably slim. Mitchell wasn't weaving through traffic. He was sitting behind the wheel of a running vehicle. But as Judge Boyd made unmistakably clear, the law doesn't grade on a curve. The state opposed probation entirely, pointing out that Mitchell had picked up this new offense just 3 months after being placed on probation for a prior DWI. 3 months. The ink wasn't even dry. And yet Judge Boyd, known for her sharp instincts and zero tolerance for repeat endangerment, didn't simply send him to prison. She issued a challenge: inpatient treatment or 5 years. Mitchell chose the chance. The sentence, 5 years prison, suspended and probated for 7. Felony drug court, SAFP if he doesn't qualify. 200 hours of community service, ignition interlock for the full term, and 20 sober meetings in 20 days. Then off the record, Judge Boyd leaned in and told a story about a man who called for his mother, only to learn he'd killed her while driving drunk. That story wasn't just for Mitchell. It was for everyone watching. Because drunk driving doesn't come with warning shots, and Judge Boyd made sure he understood. The next call for help might go unanswered. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns. because justice never gets old.